Hi, I'm Dana McLendon, and this is Ready for Trial. I'm going to answer a question today that I get asked at least once a week. If you have any further questions for me, you can contact me at Dana McLendon Law, as you see on the screen there. Also, follow me on some of the social media. Look me up as Ready for Trial on Instagram and YouTube and all those other places. I answer these and other questions frequently, and I also have a podcast where I interview lawyers and judges, and we talk about things like this and life and other things too. So the question that I get asked about once a week is, how old does my child have to be before they can decide to live with me? Obviously, this is coming in the context of a custody case where someone has got a child that goes between their house and the other parent's house, and something has prompted them to wonder, hey, when does my kid get to pick? Well, there's an answer. The answer is when they're 18. Okay. Now, that's not me trying to be a smart aleck about this. That's just what the law says. The judge maintains control over the custody of a child until the child is not a child anymore. However, there's a little bit more of a nuanced answer, and this is the one that people frequently are driving at when they're asking me this question. So let's take a look at what the statute has to say, and I'll explain a little further. Okay, this is 36-6-106. This is the statute that controls the judge's analysis of child custody. There are 15 factors enumerated here. I'm not going to go through them all. That'll be another video, much longer. But in this case, you can see here that the determination is always going to be made on the basis of the best interest of the child. Period. Always, forever. Whatever the judge finds is in the best interest of the child, that's what's going to control. Now, in making that choice, the court shall order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of the child, consistent with the factors set out in this subsection, the location of the parents, the residences of the parents, and the child's need for stability and all other relevant factors. Okay, so there's a lot of factors that a judge is going to weigh and go through before they decide whether or not a child can, quote, pick where they want to live. But there is one in particular that you should pay attention to, and that is subsection 13. Once a child is 12 or older, the judge should at least hear what they have to say about their preference. A court can hear a younger child. Frequently, judges don't want to hear from children at all, and the younger the child, the more likely it is a judge won't want to hear what they have to say. Once a child is 12 or older, the judge is supposed to hear what they have to say and give it some consideration. The older the child gets, the more the judge should consider it. Now, keep in mind that in order to invoke this section, you have to be willing to bring your child to the courthouse to speak to the judge. And that is not always a great plan for the child's well-being. So some judges will tell you, hey, if it's a custody case, I want to hear from the parents, and then I'll tell you whether or not I want to hear from anyone else, including the children. They almost always will hear a 12 or older child because the statute requires it, but sometimes they don't give it a lot of weight because children don't always say what you think they're going to say. So that is the answer to this question. How old does my child have to be to pick where to live? 18. How old does the child have to be to tell the judge where they want to live? 12 or older, if you want to make sure the judge hears them. If they're younger than that, you can ask, but the judge doesn't have to hear them. This is Dana McLendon, Ready for Trial. Follow up with any questions at danamclendonlaw.com, and follow me on some of the social media over there. I do this kind of thing all the time. Thank you very much for watching.